Sam Seder, Emma Vigeland on the Majority Report. Joining us now, Lee Hepner, Senior Legal Counsel for the American Economic Liberties Project. So Lee, before we talk about specifically this injunction, or essentially like ruling from the Sixth Circuit on net neutrality, give us a little history about this, because there's a long history about this net neutrality going back as far as I can remember from the Bush years. And then there was a lot of drama during the Obama years over this, and 3 million comments coming into the FCC essentially got Obama's FCC chair, who was a former Verizon executive, to basically say, we got to do net neutrality because I can't pretend like it doesn't make total sense.
Yeah, I mean, you want to go back to 1936? This has been this notion of open networks and sort of fair communication networks has been kicking around for quite a long time, and really it's why the Federal Communications Commission was created during the New Deal era, was to really preserve the openness and the neutrality of communication systems. And, I don't think that they were thinking about the internet at the time, but they were thinking about wire communications. They were thinking about radio. And so when you come back to when the Communications Act was amended in 1996, that's when you really get into the meat of how this is going to apply to the internet. And you're right, this has been a ping pong over the course of a few administrations. The debates were really heating up during G.W. Bush 1, but even then, you see the Federal Communications Commission, the FCC, telling telephone service providers and internet service providers that they can't block their competitors from offering a service on these communications networks. There was a really prominent order in 2005 from the FCC that kind of laid the groundwork. But in the past decade or so, this is when you see in 2015, Obama's FCC adopting the open internet rule, which is really the FCC's adoption formally of net neutrality. You see that shift back under Trump when FCC Chair Ajit Pai kind of flips the other way and overturns the open internet rule with this restoring internet freedom kind of euphemistic pivot back to sort of the privatization of this network. And then in 2024, last year, is when the FCC under Biden, again, restores this principle of net neutrality, which leads to the conflict over that, which came to us to the Sixth Circuit last week.
Okay, so there's two things I want to just go over. I mean, broadly speaking, I want you to talk about what does it mean when we say net neutrality? But I also, before we go in this, and back in the day, I could remember the Category 1 implications and the Category 2 implications of the Federal Communications Act, and I can't. It escapes me at the moment, but I want, as you describe, what net neutrality means in sort of like layperson's terms. I just want people to think in the back of their head and have this in their head. When they think of the internet, do they perceive it as a communications network, or is it just sort of like, I don't know, the way that they would look at like a billboard? I guess that they would drive by, like where it's just presentational.
Right. That's a great way of thinking about it. I mean, so essentially what net neutrality is getting at is this notion that a public information network, a utility like internet service, should be treating all types of content, sites, websites, platforms equally. This allows the network to carry, every form of information, support every kind of application, and not to discriminate between them. And the notion here is really that innovation among the edge providers, the billboards, if you will, the websites, the platforms that put content onto the internet to reach end users, to reach consumers, that innovation among edge users is going to be better, is going to deliver cooler, things if the network itself is kind of dumb, if it serves everybody neutrally and is not adapting to, say, the biggest tech platform in the room's needs and services to the exclusion of their competitors. There are some other kind of lay ways of understanding what a neutral network looks like. Think about an electricity grid. One of the common examples is that the electricity grid doesn't care what brand refrigerator you plug into it. They don't even care whether you're plugging in a toaster or a microwave. Now, certainly there are rate implications, and there's a whole nother conversation to be had about how to regulate rates on an electricity grid. Or think about like a road, a freeway, that doesn't care what kind of car you're driving onto it or the kind of tires that you're using onto it. That's kind of the principle of a neutral network.
And let me just use the negative example where, let's say you're a Con Ed customer, and they decide to get into the toaster business, and their toasters actually, if you use our toaster, it's a smart toaster, and we know you're using it, you're going to get reduced electrical rates, and all of a sudden they're going to move their toasters, and anybody else is in the toaster business, they're going to be out of luck because no one's going to want to use it because the operating costs are going to be that much more expensive. Verizon at one point wanted to roll out a music service, and if they had the ability to throttle essentially other music services, Spotify, whatever it was at any given point during the day, where your music had to keep buffering if you were not using Verizon's music platform, nobody would, you wouldn't have any other alternate music platforms. So this is crucially important to a service. And I mean, personally, I think the answer should be we can get rid of all of this question by just nationalizing it. Everybody gets an internet from the government, and then you want to provide services on it, then you can go to town. But the FCC, like you say, it's been ping-ponged back and forth under the Biden administration, reinforced net neutrality rules. Tell us about the Sixth Circuit, because this audience, if we've been successful, what we've tried to do over the past 10 years, understands the words Chevron deference doctrine.
Oh, good.
And
okay.
and how this is implicated.
Sure. So I think it's important to let's consider, before we get to the Sixth Circuit, before we talk about Loper-Bright and the repeal of Chevron deference, that two opinions out of the District of Columbia Circuit Court have approved of the FCC's initial action adopting net neutrality in 2015, and then again approved the FCC's change of course in 2017. And it's that principle of judicial deference to administrative agencies that has changed since then. And that shift is very present in what the Sixth Circuit did just last week. And the notion,
So I just want to highlight this. So under the Biden administration, I should say under the Obama administration, the court said the FCC has the power to make this assessment. Under the what was it? Under the Trump administration, the court said the FCC still has the power to make this assessment, even if it reverses what it done in the past, because this is the FCC's purview.
Right. And it's because this is a vague statute in some ways. I mean, we can parse the language and it's actually kind of tricky. But the policy of the courts was to say, we're going to be deferential to an agency's permissible interpretation of that language. And in each of those cases, even those interpretations were, inapposite to each other, those were permissible interpretations of the law. That's not the way the court is going to treat it anymore. And you see what happened with Loper-Bright, this enormous Supreme Court decision from last year that overturned this principle of Chevron deference, is that now what the court is going to do is read and adopt their best reading of the statute. So the court is going to have now the final word on what Congress meant in this kind of squishy language, even though Congress delegated to the administrative agency to interpret that language. So I think what we're seeing here is a judicial power grab, really, where the judiciary is now having the final say on the best reading of a statute, even if what they're doing is making a line call about a statute that is, kind of maybe deliberately a little bit vague.
Right. I mean, they cited it specifically in that opinion in the Sixth Circuit that, quote, is we can no longer afford deference to the FCC's reading of the statute, which is explicitly for like taking Loper Bright and applying it to this. And one of the judges of these three on this circuit was on the short list, Raymond Kethledge, for Amy Coney Barrett or Brett Kavanaugh, right? So this is a big part of the audition process, as we're probably going to get Thomas and Alito stepping aside for someone who's, I don't know, 12 years old and already a part of the conservative judicial apparatus. Like this is auditioning for the conservative judiciary machine, basically.
Yeah, and I don't think that that's really the way most Americans think how the judiciary should operate. This is not this is not a political audition, and yet that's exactly what is happening. You see, I think in the wake of Loper Bright, we're going to see a lot more judicial activism because the judiciary has been thrust into this role of having to decide policy nationally. And that's not really been the role of the judiciary. That's kind of counter to our entire system of separation of powers, of democratic accountability in our society. The Sixth Circuit opinion is really the first big opinion since Loper Bright to shine a bright light on this, but we're going to see a lot more of it.
All right. So Lee, there's a couple of things I just want to make, clarify for people because, the words judicial activism, I haven't heard really used that much since the aughts, when conservatives were complaining that's supposedly what the liberal judges were doing. There is a fundamental difference between interpreting the law, which is the job of judges, right? When there is a question of a law's vagueness. But this is a second order interpretation because within the law is already Congress's delegation of making these determinations to the FCC or any given agency. Congress can't sit down and say, these are all the things that could be making water dangerous to drink because they don't know them. We don't know the new chemicals that may be dumped into a river. We don't know in the future. You need to provide the scientists and the professionals who work at the EPA the ability to make this assessment. This is also what the FCC was delegated to do under this, was like, you make this assessment as to, how the internet functions on any given situation. And now the court's stepping in with their own. So if the Sixth Circuit can do this, can, I don't know, the DC Circuit weigh in with a different opinion? And would we have different FCC abilities in different circuits unless it went to the Supreme Court?
Yeah, I mean, it's a great question. And it's one that we're grappling with in a few different contexts where you see, for instance, when the FTC adopts a non-competes rule, different topic, but a court, setting aside that rule nationally, a district court, a federal district court, what is the implication of that for other district courts that aren't necessarily bound by a sister court? You could be, encountering the same thing here, where you might see, you theoretically could see a different circuit court saying, hey, actually, we think the best reading of this is that broadband ISPs are a telecommunications service and a public utility. We're not bound by the Sixth Circuit, and we don't agree with their reading of the statute. Theoretically, you could see that happen. I suspect that it won't, and that if you follow the thread, the real imperative here is for Congress to act and correct this. And maybe that's the kind of desired end game for some of the corporate powers who are pulling some of the political strings here, is that, Congress has demonstrated an inability to act on major issues affecting corporate power. And so putting the onus back on Congress to govern is really, a good position for the broadband ISPs to be in.
And particularly because it's also setting precedents, like I say, across other industries and other regulatory agencies. This one might be just like a sort of a binary. Are they a communication network, or are they some type of like presentational network, an information service, as opposed to a communication service? That may be somewhat binary, but like I say, this is setting a precedent across all sorts of different agencies. Now, this, we knew this would happen after Loper Bright, and we're seeing it into play. All right, last question for you. California, for instance, has a very strong net neutrality rule.
Yeah.
Is it possible that when you have a market share like California has, or like New York, will that implicate the national policy going around by these providers, or is our provider network so sort of like disaggregated in some way, and not decentralized, but just sort of like patched together, that it won't implicate something like net neutrality?
I mean, this is the real Civil War, isn't it? So, the delegating these policy decisions to the states is the other big opportunity here. And in 2017 or 2017, when Trump's FCC repealed net neutrality, right, California stepped in and said, hey, we're actually going to regulate. We're going to do what Congress has failed to do at the federal level. And we're going to say, as a matter of statute, that net neutrality is the law of the land in California, and we're going to have fair and open and neutral networks. Does the power of the purse, does the regulatory magnitude of California have a nationwide effect? I think arguably, maybe, yeah. I don't think it's any more convenient for corporations to have a patchwork compliance regime. It might be easier for them just to adopt one. On the other hand, there's a really significant financial incentive here for corporations to make a lot of money by exploiting the control that they can now exert over broadband ISPs at the state level. I mean, that decision in 2005 by the Republican FCC under George W. Bush that I mentioned, that was actually as to a local ISP that had tried to block access to an internet phone service provider. So some of this stuff is actually local at the broadband ISP level, and those integrations between big tech and more local broadband ISPs, they're not going to care what California did if they're sitting in a state that has not stepped in and adopted net neutrality.
All right, one last question. I lied about the last one being last question. Is there, are we going to see, it seems to me, I mean, and people forget that the Chevron deference doctrine was originally a case brought by essentially environmental activists who were forcing the EPA to do more, essentially to do more regulation and uphold regulation. And the court at that time said, you got to defer to the EPA. It was actually Gorsuch's mom was the head of the EPA at that time. Are we going to start to see more actions like this, where people are going to go to courts in circuits that are friendly towards regulation, and people are going to say the EPA is not doing their job, or the DHS is not interpreting this law on immigrants properly, or et cetera, et cetera, et cetera. And are we going to see these courts start to impose, sort of like keep the Trump administration from running their agencies like they want to?
Yeah, I mean, first of all, yeah, you're totally right that this is not a partisan issue. The nature of administrative rulemaking and judicial oversight or intervention or repeal of administrative rulemaking was actually a huge burden to Trump's first term agenda, as it was during Biden's agenda over the past 4 years. And we're likely to see a lot more challenges again. I mean, the other big Supreme Court opinion that came out in the last session is a decision called Corner Post, which actually makes subject to challenge any rule that an administrative agency has ever adopted. So ordinarily, you could only challenge a rule, during a statute of limitations period that ran from the point at which the rule was adopted. Now you can challenge an administrative rule anytime after you, a private company, has been harmed by the rule. So it really restarts the clock to challenge any number of administrative rules. So you see the administrative agenda over the past, several decades now on the chopping block. I think we're going to see a lot more challenges, and we're really seeing a sea change in what the administrative state can do.
Lee Hepner, Senior Legal Counsel for the American Economic Liberties Project. Thanks so much for your time today. Really appreciate it.
My pleasure.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.